Good afternoon and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace and I'll be presiding over the case here today. I have joining me on this panel from Orange County, Judge Jay Cohen, and from Seminole County, Judge Eric Eisnagel. We have one case on the docket at 1:30, that is State of Florida versus Cindy Lee Schofield. And I would just ask everybody to make sure when you're not speaking that you have your microphone muted. And if you have any noise making devices, put those on mute too, so they don't interrupt the presentation. And I will assume that the state wants 5 minutes for rebuttal unless you tell me otherwise, Ms. Davenport.
5 minutes is fine, thank you.
Okay, great. And then you may proceed.
May it please the court, my name is Chris Davenport and I represent the state. This is an appeal from a county court judge's order granting a motion to suppress a blood test for blood alcohol content in a DUI case. The question here is whether or not the defendant voluntarily consented to that test. The trial court ruled that she initially consented voluntarily, but that as the circumstances changed, there was some question about that, and the police had an obligation to clarify to make sure that she was still voluntarily consenting after the circumstances changed. In her initial consent at the time of that, the police officer had gone through I'm switching hats now. This is no longer an accident investigation. I'm now investigating a criminal offense of driving under the influence. This was after the defendant had failed the field sobriety tests. And the officer said, look, I know that you said you had a neuropathy.
Ms. Davenport, how many field sobriety tests are there?
How many are there?
Yes, and the law enforcement battery of field sobriety tests.
It's hard to keep up with that, Your Honor, because I know some of them have been invalidated, but there are certainly several field sobriety tests. They only tried 2 here.
Okay, so I don't ever remember there being any type of conclusive determination that she failed the field sobriety tests. I believe that there was quite a discussion on the videotape about whether or not she could perform the field sobriety test based upon her neuropathy and her reliance upon her walking cane. So is there something else on the videotape that I was missing there?
Nope, I perhaps spoke too strongly. I think was unable to perform would be a better way of putting that. Even when you fail field sobriety tests, they don't tell you that. She was unable to perform the tests that they did. She couldn't follow the instructions, didn't follow the instructions with the eye test, or they're having her follow a pen without moving her head. And then they tried the walk and turn and she was unable to do that. And, she was cold. It was a very cold evening and she was walking with a cane. So she said she couldn't do that. And she said she had neuropathy, was taking gabapentin. And so the officer said, look, sometimes neuropathy comes across like you're intoxicated. How about if we do a blood test to see what your blood alcohol content is to make sure you weren't driving while you were under the influence? The defendant said, yes, that's fine. The officer said, we can either do a breath test or a blood test. It's totally up to you. The defendant chose to do a blood test because she was used to being poked and prodded with her medical issues. And then they said, okay, we'll do the blood test then. Again, she was clearly being investigated for DUI. This wasn't just a random, hey, let's go do your blood. I mean, she was suspected of that. She was being detained. She had been there a while. This was in minute 45 of the police officer's body cam.
Isn't the most important issue here? I mean, maybe it's not, correct me if I'm wrong, but isn't the most important issue here the consent that was given during the investigation before the officers indicated that they had made a probable cause determination and a decision to arrest, correct?
It was before the officers had decided to arrest her, yes.
And so that isn't the most important issue here whether the consent remained valid once the law enforcement officers then made the decision after consent had been given, then made the decision to go ahead and make an arrest? Isn't that the most important question?
The important question here is whether or not her consent is voluntary. The reason I bring up so many facts when she initially consented is to show the situation really didn't change from a practical point of view. She was being
really,
investigated. She was
that's
being-
odd, because if I were the individual and I was told, well, listen, let's straighten this all out. If you agree to go ahead and give us a blood sample, we can check and see if you're impaired. And then it changes from that to being arrested. You don't think that that's a significant change?
She was already detained. She was already being investigated.
She wasn't placed under arrest.
She wasn't placed under arrest.
She had agreed to voluntarily go down to the hospital and give blood, and then all of a sudden she's arrested. You don't think that's a significant change?
I think that that's
That's a yes or no. Yes or no. Either you do or you don't.
I would agree that it's a change. Yes, significant
Let's-
change. Sure, that's probably pretty significant to her.
Okay.
But as far as what happened, as far as how the blood was going to be drawn, the officer didn't say, you can follow me or don't worry about it. You're not going to be arrested as long as you consent. There was no bargaining like that. What she said was, we're going to put you in a patrol car and I'm going to take you to the medical center so a phlebotomist can do the blood draw.
But counsel, I
And
mean,
you know what happened?
Here something that I find troubling. In your brief, page 14, you say, quote, that that her status change from detained to arrested did not somehow require further inquiry into her continued cooperation in the absence of any indication that she had reconsidered her choice to cooperate. No citation to authority whatsoever. That seems like a very conclusory statement. Can you justify that statement for us?
I would say there's nothing in Florida law that says that if you consent before you're arrested and then you're arrested, you have to consent again.
Is there anything that says the consent? Is there anything that says the
You got any
consent?
case law that supports that proposition?
There is no case law that says that. There is case law discussing how consent can be vitiated. The defendant can revoke it. The defendant can change the scope.
All right, so you have no
implicitly or
case where
explicitly.
you have no case to cite for the proposition that when someone's told, listen, you can go down to the hospital, voluntarily give blood, we can see if you're impaired, and then the police then instead place the individual under arrest. You have no case law that has that set of facts, correct?
I have no case law on that either way. What I have is case law explaining how consent can change. The defendant can do something or the police can act illegally. If they had illegally arrested her, this would fall squarely under the Johnson case that I cite at page 16 of my brief. They didn't do anything wrong. They had probable cause to arrest her. The defense counsel never argues otherwise. And they didn't do anything to illegally, if there's an illegality, that can taint consent. But they didn't do anything illegal here.
Counsel, I do understand your argument. I think that the problem, this thing I'm struggling with is do you agree that whether there's an investigation versus now officers have made a probable cause determination, they have determined that there's probable cause for your arrest and they arrest you. Do you think that might be material to an individual's decision on whether they would want to consent?
I think that a legal arrest does not vitiate consent in the absence of any indication from the defendant herself that she has changed her mind. She had plenty of opportunity to say, wait a minute, this isn't what I agreed to. She's being put into a patrol car and taken to the hospital, which was what they said up front when they asked her if she would consent to a blood draw.
Look, your argument is a fair argument. I'm just not entirely sure it carries the day. Here's the thing. Your brief says, hey, look, what they told her would happen happened exactly. Essentially, that's what your brief says. I'm not sure that's right. She agreed to go down and have a blood draw under investigation. She did not agree to go down and have a blood draw under arrest. And I guess my question to you is, why is that not material, that difference material?
Because she voluntarily consented to go in a police car and be taken to a hospital. They put her in the police car before they put her under arrest.
Wait. For purposes of them, determining whether she was under the influence, meaning that if she gives this test and it comes out well, that she's not going to be arrested. And then, well, but that's the implication. That certainly is, the implication. And then they turn around instead and place her under arrest.
I think if they had said, we're not going to arrest you if you cooperate and this blood test comes out okay, I would absolutely agree with you, Your Honor. They never implied that
Counsel,
it would be the end of anything.
Explain to me how it's unreasonable for a defendant in this situation to believe that if the blood test turns out clear, that they can't be arrested. Well, just walk me through that.
Well, if they had told her that, I think this is really speculating.
I'm not asking it. I understand they didn't tell her that. I do understand that. But answer my question as phrased. How is that not just a sort of an obvious assumption that any defendant would make? If I go down and do this blood test and it's clear, then I won't get arrested. How would you walk me through how it comes back totally clear and the arrest is made anyway?
If a defendant if we have probable cause that a defendant is driving under the influence, there's, I believe, a statutory requirement that they be put in jail for to basically, sleep it off. We don't put them back. They're going to get arrested for that.
If the blood test comes back completely clear?
But the blood test doesn't come back immediately. The blood test the blood has to be analyzed. I mean, here it was
from the defendant's perspective. From the defendant's perspective, I mean, look, I've looked at the record here. What happened? Why was it not a reasonable belief that, hey, if I just go down and do this blood test and it's clear, we're good to go? Why, from her perspective, why is that not what she was reasonably thinking?
Well, there's no evidence that that's what she was thinking. I believe if that's what she was thinking, when they said you're under arrest, she would have said, wait a minute. You told me if the blood test was clear, I'm not going to be arrested. She didn't. She expressed surprise that she was being arrested. She was like, why would you arrest me? Because I'm on my medication. She clearly didn't think she was under the influence. But she
Davenport, I think the record's different, respectfully, on 22.33 of the video. The statement by the officer was, we're going to check your blood to make sure that it's clear for not being under the influence of alcohol. That is around the time that she consented. And then later on, you're saying she never expressed surprise about being arrested. She did when she was put in the car, and after the car door was closed and the audio on the body cam footage was turned off, there was a conversation had, and then the officers came back to the car door and then immediately told her she was under arrest. That's when she expressed surprise as to why she was being arrested. Isn't that how the facts kind of played out in this scenario?
I agree with both of those things, with the caveats. Yes, they made it sound like it was a good idea for her to cooperate and have her blood drawn. If she thought she wasn't under the influence, this would show it. Just like when people come in to give statements to the police say, tell us your side of the story. Let's make this sound like a good idea to cooperate.
So do you think it was
nothing wrong with that?
You think it was a reasonable conclusion for her to make that when that first statement was made to her that she was under arrest? Is that what you're saying?
She wasn't under arrest then. We're not saying that she was. The situation certainly changed. But as far as the surprise when she was put under arrest, yes, absolutely. She seemed surprised by that. And
was she ever advised what are the consequences if, first off, that you have a right to choose whether to cooperate with the test or not? And then what are the consequences if you choose not to cooperate? Was she ever given the clear description of what the consequences are?
First of all, she was not told that she didn't have to consent. That does not make the consent involuntary. She was not told that there were consequences for her failure to consent because they weren't going under the implied consent statute. They were operating under the voluntary consent. And if she had said, no, I'm not going to do a blood draw, the consequences would have been nothing. There are no consequences to that. They were just asking if she would do that, waive her right to privacy and do the blood draw. There were no consequences to tell her about. As far as her surprise when she was arrested, she
Counsel,
seemed genuinely surprised.
do you agree that you seem to rely pretty heavily on Luna Martinez versus State in your brief? Do you agree that that case is not on point as far as consent, then arrest, and then a decision that the consent was valid, still valid after the arrest? Do you agree with that, correct?
I agree that the circumstances in that case are very, very different. Yes. I rely on it for the principles of, the de novo standard of review and for what happens when you read Miranda. And the court in that made it clear that Miranda doesn't make it more coercive. If anything, it takes some of the coercion away. I see my time is up, so I would like to reserve the remainder of my time for rebuttal.
Okay.
That
Very
assumes, of course, that Mr. Hicks makes an argument.
I think what I'll do, and first off, I'd like to introduce myself again. I'm Jason Hicks. I'm a counsel for the appellee, and I don't expect to use all of my time. I'll try to be
Do you
as brief.
expect to use any of your time?
Yeah, but abundance of
All right,
caution.
go ahead. You go
Okay.
for it, Mr. Hicks.
If it's a mistake, then I'll learn. I apologize.
Okay.
Nonetheless, I just want to reiterate the fact that at the time, and you're already touching on it, so forgive me for reiterating it, but at the time that she's originally asked for a breath or blood was the first request. She was not under arrest at that time.
Mr.
Was
Hicks,
there any
we've gone
case?
through that. We understand all that. You don't need to
Understood.
repeat what we've already gone over.
Very well. I would just
Is there any
focus on the-
case? Is there any case that you know of in any jurisdiction addressing whether a consent given before an arrest remains valid then after law enforcement then makes an arrest?
I don't know a case either way. I have not seen a case where somebody was providing consent to waive a right and then ultimately was arrested and then advised of some vague negative consequence if they were to revoke that previously given consent. I haven't seen a case like this. And I assume that's why we're here today, because I don't think the state had anything on point with regard to that either.
Mr. Hicks, on the video, your client says, "I'll do whatever you need me to do." And that was 22.23 into the video. How is that not consent?
I would say, and if I don't claim to have it memorized, but if that came before she was under arrest, at the time she's agreeing to supply a sample at that time, she appears to give consent in the language of consent. She's asked for a investigatory is what I'm calling it. Law enforcement didn't call it that. But at the time she's under investigation, they said something to the effect of, let's take you down there and make sure that we will make sure that you are clear for DUI is what I thought that they said. And then she provides a consent under that investigatory phrasing that was given to her by law enforcement. Then they place her under arrest under supposed purported probable cause for arrest for DUI. They don't utter that words to her, but they tell her she's placed under arrest for DUI. And the client asks, why DUI? She does show surprise. And it's at that time she's led to believe I would say at a minimum, an implied threat of a negative consequence if she was to revoke that previously given consent. The officer specifically says to her, I have to read you this by law. The officer even testified at the hearing itself that she believed she did have to read implied consent to my client at the time that she actually gave the language of implied consent. And then she impliedly, I would say expressly, threatens my client with some sort of consequence if she was to revoke that consent. The officer says, I'm now asking you to submit to a blood test. If you refuse to submit to this test, your driver's license will be, and then of course she doesn't finish that sentence. But I think any individual in that situation hearing these words it's implied that there will be a threat. If she exercises a right to revoke that consent and invoke her right to privacy. And it was a it was a hollow threat that did not have teeth. They could not take any action on her driver's license if she was to revoke that consent. And they're giving her affirmative misadvice about her right to revoke consent. And that can't stand. And obviously we would ask the court to sustain the lower court's ruling in regards to that. And obviously with consent, there cannot be an express or implied threat to get that consent. And I would imagine it's got to be the same way to maintain consent. You can't continue to give a false threat of a privilege, in this case, being negatively impacted. And I have nothing further to say in that regard.
Thank you, Mr. Hicks. Ms. Davenport.
No, I'm not done with Mr. Hicks quite yet.
Okay.
Mr. Hicks, this is just, since we've got extra time, this is just a friendly suggestion to you. Do you know how many times in your brief you bolded either sentences or portions of sentences?
I don't know the exact amount, and if it's not a good practice, I'm learning. Thank you.
16. If you write a brief and you and this is just a suggestion for future, because
Appreciate it.
I had this occur in a civil case many years ago where I got a lot of underlining and exclamation points and things like that. If you write a brief that's persuasive, then it's unnecessary to bold. In fact, I would go as far as to call it distracting and unnecessarily so. So I'm just suggesting this on a go-forward basis that you avoid that technique in terms of writing your briefs. So for what it's worth, I'm just suggesting that to you, okay?
I appreciate that advice very much, sir.
No problem.
Thank you,
Thank you,
Your
Mr. Hicks.
Thank you.
Ms. Davenport, you may proceed.
Just briefly, Your Honor, as far as this implied threat from reading the implied consent warning, the beginning of it, let me just say they stopped before the threat part. And if you watch the video, the defendant's response to that implied consent, which they never even called it implied consent, she winked and she smiled. She was not coerced by that. But more importantly,
What if the consent had been given in this way? What if law enforcement had expressly said, look, let's go have a blood draw, and if the blood turns out clear, we're good to go. You can go home and we'll have no reason to arrest you. Do you want to go down and do this blood draw? And she says, yeah, that sounds great. Let's do it. And then the same thing happens here. She's in the car and then they say, well, actually, no, sorry, you're under arrest. And the exact same, everything else happens the same. Does that change your analysis?
absolutely. I think in that situation, they bargained for her consent in exchange for, we're going to let you go. And then they changed the terms of that. And I would say that does render it involuntary because they had a deal and then they changed it. That's not what happened here. They never said, you're not under arrest. We're not going to arrest you. Cooperate and you won't be arrested. None of that was ever said. None of that was ever implied. If the defendant had that in her head.
Sure it was. Sure it was. They tell her, listen, we're going to go down, you're not going to be handcuffed. We're just, we're going to put you in our car. We'll take you down and straighten this all out. I think that's absolutely what was implied.
We're not going to handcuff you because I know you have to have your cane. And she was put in the patrol car before she was told that she was under arrest. You can't have your purse and we're going to take you in your patrol car and I'm going to pat you down. And we're going to take you down to the hospital in the patrol car and take your blood. The only thing that changed because she was arrested was where she went after the blood draw. She went to jail instead of being brought back.
No, counsel. I'm not sure. You're going to have to work on me there. You're going to have to give me a better explanation of that, because it seems like something did change. The officers went from, hey, we're an investigation, we're trying to determine if there's probable cause to make an arrest, to, hey, we've decided and we are making the arrest. I mean, to me, that seems like a substantial change.
But people get arrested and still voluntarily consent all the time.
Right, but this one didn't. This defendant did.
But she'd already consented. If she wanted to change her mind, all she had to do was say, hold up, you
But
guys.
wait a minute, what? And I hear you. Fair enough. But why is the burden now suddenly shifted to her when the officers are the ones who totally changed the dynamic?
For two reasons. It's always your burden if you change your mind. There's a lot of cases that say you can revoke consent. None of them say, we're going to read that in.
Counsel,
when
the
you haven't said
officers,
anything."
no. The officers changed their mind. They're the ones who changed their mind.
The officers didn't change any part of the deal. If she didn't want to cooperate anymore, all she would have had to do was
Oh,
say, I
sure
don't
they
want to
did.
cooperate anymore.
Sure they did. What happens is that the corporal gets involved and the whole thing changes. This officer intended to do exactly what the officer told the defendant, which was to take her down to the hospital and draw blood. And the officer knows, because she'd been doing DUIs, that it's going to take a while to process that in any event. And what changed is that the corporal gets involved and the corporal changes the dynamic.
I believe that she would have been obligated to take her to jail because she was driving under the influence. I'm not positive about that, and I could be wrong. But I believe if you arrest somebody for DUI, they have to spend a certain amount of time in jail. Would she have let her go? Again, we're all speculating here. And let me say there is not a case that I found finding that consent is rendered involuntary. Voluntary consent changes in the absence of the defendant affirmatively doing something to revoke or limit it, or in the presence of police misconduct. And there's no police misconduct here. Nothing says that properly arresting somebody changes the analysis and renders your prior voluntary consent involuntary. And if that's what the rule is going to be here, I hope this court writes, because the police officers need to know that, because there's nothing that says that right now. I see I'm out of time. If the court has no other questions, we would ask you to reverse.
All right. Thank you, counsel. Appreciate the argument. And we're in recess. Have a great day.